Nichola is the CITES licensing manager working for the Joint Nature Conservation Committee, which was appointed by the Secretary of State as the UK CITES Scientific Authority for Fauna in 1991. Joining the CITES team in 2001, she has over 20 years' experience of CITES licensing and has developed close working relationships with all stakeholders, including zoological and museum collections and the scientific community. She is responsible for the management of JNCC CITES Advisory Service and of a team of 7 full-time licensing advisors who provide advice to the UK government on approximately 25,000 licence applications annually, which must keep you very busy. So thank you very much to Nichola for coming, and I will not impede on your speaking time anymore.
Thank you, Laura. Yeah, fab. Okay, so as Laura said, my name's Nichola Burnett and I work for the Joint Nature Conservation Committee. And the JNCC is a nature conservation organisation that's responsible for advising the UK government and the devolved administrations on UK-wide and international nature conservation issues. We have about 270 staff based in offices in Peterborough and Aberdeen, although we do have staff working remotely as far away as Wales and the Falkland Islands. And so our role really is to provide evidence, information and advice to policymakers in the UK, Europe and internationally, so that the right decisions can be made to protect our natural resources and systems. We also support nature conservation in the UK's 14 overseas territories and 3 Crown dependencies, all of which are very important for global biodiversity and geodiversity. And so one of our functions is to act as the UK CITES Scientific Authority for animals, and the Royal Botanical Gardens offers the reciprocal function for plants. So it's in this regard that I'm talking to you today. So just to run over what I will talk about this afternoon, I'll just try and give a very concise introduction to CITES and how it's implemented in the UK. I focused a little bit on the commercial use and display of Annex A specimens because I think that's probably what's quite relevant to you. And then I'll give a very brief introduction to the Wildlife and Countryside Act and how that kind of crosses over into the CITES work. So CITES stands for the Convention on International Trade in Endangered Species of Wild Fauna and Flora. It was signed on the 3rd of March 1973, so CITES is 50 years old this year, so happy birthday CITES. It entered into force in 1975 and the UK joined in 1976. There are today 184 countries that have signed up to the CITES Convention, which makes it one of the most successful international nature conservation agreements in terms of global coverage. I mean, with hindsight, the need for an agreement like CITES is very clear. Annually, the international wildlife trade is estimated to be worth billions of dollars and includes hundreds of millions of plant and animal specimens. And this trade is really diverse. It ranges from live animals and plants to a vast array of products that are derived from them, including food, leather goods, musical instruments, timber, tourist curios, and medicine. And the levels of exploitation of some animal and plant species can be very high. And when you combine the trade in those species with other factors such as habitat loss or climate change, that could be capable of heavily depleting their populations and bringing some species close to extinction. The majority of wildlife species in trade are not endangered. However, the importance, the existence of an agreement to ensure the sustainability of the trade is really important so that we can safeguard these resources for the future. Because the trade in wild animals and plants crosses international borders, the effort needed to regulate it also requires kind of international cooperation, and CITES was really conceived in the spirit of international cooperation. So CITES is legally binding on parties. However, each party to CITES must enact its own national laws in order to implement the convention at the national level. So CITES provides the framework really that has to be respected by each party. And today there are nearly 40,000 species of animals and plants that are listed on its appendices, and it doesn't matter if they're traded as live specimens, fur coats, or dried herbs. The most recent influx of species listed on the appendices came into force on the 23rd of February this year, following the CITES Conference of the Parties in Panama. So CITES works through a system of permits and certificates, and these permits and certificates cannot be issued unless certain criteria have been met. And these documents need to be presented and checked by customs or border force officials when they enter or leave the country. So species are listed on one of three appendices according to the degree of protection they need. So this isn't really according to how endangered they are, if you think about the IUCN Red Lists, but it's about how threatened are they by trade. So Appendix 1 contains those species that are threatened with extinction and for which trade is subject to very strict regulation. Trade in Appendix 1 species should only be authorised in exceptional circumstances and for certain purposes. However, only 3% of species are listed on Appendix 1. Appendix 2 is a list of species that are not threatened with extinction. However, they might become so if you do not regulate and monitor the trade. So the majority of species listed on CITES are listed on Appendix 2. 96% of species on CITES are listed on Appendix 2. And Appendix 2 specimens can be freely traded, imported and exported, subject to getting the correct permits. Appendix 3 contains those species that are subject to regulation within the jurisdiction of an individual party, and that party has requested the cooperation of the other parties to prevent or restrict their exploitation. Only 1% of the species on CITES are listed on Appendix 3. Kind of import notifications are issued for Appendix 3 species as opposed to import and export permits. So each party to CITES has to designate one or more management authority that are competent to grant permits and one or more scientific authority in order to advise the management authority. So in the UK, we've got two management authorities. We've got DEFRA, who are responsible for the CITES policy. They represent the party at international meetings and liaise with the Secretariat. And then we have their kind of subsidiary agency, the Animal and Plant Health Agency, or APHA, and APHA are responsible for the delivery of the system. So they're responsible for the issuance of the permits and the certificates. So if any of you have ever applied for a CITES permit, it's to APHA that you will make your application. But the management authority is also responsible for preparing for meetings for the Conference of the Parties. They communicate with the CITES Secretariat. They're responsible for enforcement issues. They're responsible for preparing the UK's annual reports and any reports on illegal trade. And then in the UK, we also have two scientific authorities. So JNCC is the scientific authority for fauna, and the Royal Botanical Gardens Kew are the scientific authority for plants. And the scientific authority advises on the science behind the applications. So our primary role is to advise the management authority of whether the export of any specimen would be detrimental to the survival of the species in the wild, and that's called a non-detriment finding. And that is usually a desktop review of all the available information about a species from a certain country. So we might look at the status, its distribution, the population trend, any other harvest information, harvest trends, quotas, and any other biological or ecological factors, as well as the current or anticipated levels of trade. We advise on approximately 25,000 licence applications a year just to JNCC. So our primary aim is to make sure that the UK trade is conducted sustainably and within the parameters of the regulation. And we take each application on a case-by-case basis, looking at the details of the case and the conservation implications of allowing the trade. So this could be deciding whether or not an import application for a consignment of 200 leopard tortoises from the wild in Ghana would be detrimental to the survival of the species in the wild. Or it could be assessing whether a golden eagle has been genuinely captive bred as claimed, or whether it's a wild-taken specimen that's being laundered through the system. And in that respect, we might have to involve extensive inquiries, checking breeding records and seeking advice from taxon experts. A key point to note is that if the scientific authority is not able to make that sustainability assessment, the management authority is obliged to refuse the application and the trade cannot go ahead. So what do we mean when we talk about a specimen? So what is controlled? So a CITES specimen is an animal or plant, alive or dead, of a CITES listed species, but it also includes all the readily recognisable parts and derivatives of that specimen. But what do we mean by readily recognisable? Well, you can either recognise it instantly as being a CITES listed species, or it can be identified from any accompanying documents, packaging, mark or label, or any other circumstance to be or to contain a CITES listed animal or plant species. So, for example, if the ingredients on a packet of pills, like these ones in the picture, if the ingredients list says that it contains derivatives from tiger, then those pills are covered by CITES as if they did contain tiger, even if subsequent testing reveals that there is no tiger contained in them. And it's important to note that, just having a picture of a tiger on the box isn't evidence to show that it contains tiger. Otherwise, all boxes of Frosties would be confiscated. It actually has to be listed in the ingredients. So now that we've left the EU, imports and export permits are required to move CITES specimens between the UK and EU member states. So obviously prior to that, there was free movement of CITES species around the EU, for, exactly the same as any other good. But now, obviously, import and export permits are required, and this resulted in a significant increase in our workload and also a complete change in our permitting procedures as well. So it had a significant impact on our working day. Other problems that we have encountered arising from EU exit have been logistics at the border with increased volume. Border Force obviously have a responsibility to check shipments that are going in and out, so they needed extra capacity for that. But also, we're no longer part of that joint decision making. So within the EU all work to the same regulation, and they all coordinate and work together to form a joint opinion on trade issues. And that was a big decision-making forum and a source of an awful lot of information. We had many other experts in the EU that we could reach out and consult if we needed to. And now we are kind of separated. We now rely on our own views. And so consequently, we are accountable more for our own decisions. So when we left the EU, we inherited the EU wildlife trade regulations that we were working to. They were simply transposed into UK law when we left with very limited amendments. Essentially, all the amendments that were undertaken were replacing references to the EU to the UK. So essentially, they are at the moment still virtually word for word identical to the EU regulations that we were previously working to. So our UK regulations are, identical to the EU ones, and they go beyond CITES in many ways and contain a raft of stricter domestic measures than are required by CITES. So the main differences are that we have 4 annexes. So CITES has Appendix 1, 2, and 3, and we have annexes A, B, C, and D. And they roughly equate to the CITES appendices. So Annex A is roughly the equivalent to CITES Appendix 1, and so on. We have Annex D that doesn't have a CITES equivalent, and that's really a bit of a monitoring tool to monitor numbers coming in. And then it might flag up where levels of trade are starting to become an issue for some species. Our annexes can contain non-CITES species. Previously, when we were in the EU, they commonly included many species of European concern. We have stricter import conditions. So usually for the rest of the world, trade can take place in Appendix 2 species on the basis of an export permit issued by the exporting party, whereas the EU and the UK regulations require an import permit to be issued for Appendix 2 species, and it requires also a non-detriment finding to be made by the importing party, which is in addition to the non-detriment finding made by the exporting party prior to the export permit being given. So you get a doubling up. You get a doubling up of the sustainability assessment, and it's kind of reversing the burden of proof. So the non-detriment has to be clear to the importing party as well as the exporting party. We have the ability to put in place import restrictions. We can suspend import of species from particular countries where we feel that the trade is not sustainable. And we also restrict internal commercial trade of our Annex A specimens. If you ever want to find out whether a particular species is listed on the CITES appendices or the EU annexes, then a very easy way to check is to use the Species Plus database. We use this database on a daily basis. The website address is just on the slide there. So if you enter the species name in the page that you see in front of you and click search, then it will bring up all the useful information that you might want to know. It has tabs for taxonomic names, countries of origin, and then it has information about species listings, annex listings, quotas, and any trade suspensions. It is important to note that this database will show you the EU listing, not necessarily the UK annex listing, because the EU pay UNEP WCMC to maintain this database, so it reflects EU rather than UK. So I wanted to touch on commercial use because I think it's an issue that might cause some questions when museums or other scientific institutions might be displaying any Annex A specimens to the public. So all those commercial activities that you see in the bullet points there are all prohibited for Annex A specimens unless you have obtained an exemption in order to undertake that commercial activity. And so an exemption certificate is commonly called an Article 10. That's one that is for an individual specimen. And an Article 60 is for an institution. And I will just go into it in a little bit more detail now. So some of you may have an Article 60 certificate for your museum. It's not completely necessary to have one. It's not mandatory to have one. So scientific institutions can apply for one Article 60 that will hold multiple and will cover the use of multiple Annex A specimens in their collection, provided that the specimens in that collection are being used for either breeding, research, or education aimed at the conservation of the species. The certificate will look very much like an Article 10. It's just in the taxonomic box there. I've highlighted on the slide, it will say all Annex A specimens instead of having an individual taxon name. So are there any exemptions to these commercial restrictions? Well, there are just 3 exemptions, but there's only one that I think was really relevant to yourselves. And that's the one for antiques. So as far as CITES goes, anything that predates 1947 is considered to be an antique. And if a specimen is a worked antique, then it doesn't require an Article 10 in order to be used commercially. So specimens are considered to be worked. The definition in the regulation is that they must be significantly altered from their natural raw state for the purpose of art, jewellery, adornment or musical instrument, and they require no further carving, crafting to affect their purpose. So for example, we have this tortoiseshell tea caddy that's clearly been significantly altered from its natural raw state and needs no further work. And then we have these bagpipes, which have ivory components. And again, clearly you can see it's a finished item that's been significantly altered from their natural raw state. Whereas here we have the kind of derivative in their natural form. Obviously, a turtle shell carapace in itself is not significantly altered from its natural raw state. So here we have a few more examples of what is considered to be worked or unworked. So if you see on the one hand side, we have the taxidermy, taxidermied barn owl. Taxidermy is generally considered to be significantly altered from its natural raw state. We've got a rhinoceros horn libation cup. We have the tiger skin rug. This particular rug has been significantly altered. It's got a mounted head and the skin has been backed on felt. Sometimes you get skins that have not been backed on felt and have a flat head, and that is considered to be unworked. You've got the cat skin coat and the ivory carved tusk. An ivory tusk has to be carved, I think, over 60% of its surface. And then on the other side, you can see that you've got the ivory tusks surrounding a gong. Well, the tusks have simply been mounted and polished. They've not been significantly altered. The same goes for the rhino horn on the shield. It has been mounted on a shield, but you could just cut it off, and then you still have essentially an unworked horn, and the tortoise shell as well is unworked. So any antiques, so you might get an item that is an antique, it's pre-1947, but it doesn't meet the definition of worked. Well, in that case, you need to have an Article 10 certificate in order to use it commercially. All the big auction houses are all very aware of CITES and they should be complying with the regulations. But occasionally you do still see items being sold through smaller auction houses. And so it's important to just remain vigilant. And it should be noted, so there are no controls on possession. You are allowed to possess an Annex A specimen, and you can also gift it away in a non-commercial transaction. You don't need an Article 10 to do that. An Article 10 is not a certificate of ownership. It's only needed if you are going to use it commercially. So I thought I'd just run through a few examples that may be pertinent to some museums or other establishments, in case there's any confusion about what should or shouldn't be considered to be commercial if you have Annex A specimens in the collection. So this first one is if you have a permanent display with Annex A specimens. If you charge an entry fee for the public to come in and view your Annex A specimens, then you would need an Article 10 certificate for that. If you don't charge an entry fee, or even if you have a voluntary donation box, then a certificate is not required for that. At the end of the day, the management authority is responsible for making the ultimate decision about whether an activity is commercial. So sometimes, you need to take a bit of a pragmatic approach, and it's sometimes open to a bit of interpretation. So, for example, the voluntary donations, if the donation box is there and the public can freely walk past it if they wish, then that's not commercial. But if you have people shaking a tin under the public's nose and being a bit more pushy about the donations, then that might probably be considered commercial. And then we might have a temporary event. perhaps an evening event that might be held in the museum, or a specific exhibition going on. So if you charge an entry fee in an otherwise free museum to see those Annex A specimens, then you would need a certificate. Or if you had a commercial event where the Annex A specimens are really integral to the event, then I suggest that you need a certificate. However, if you're holding a commercial event at the museum and the Annex A specimens are just incidental, they're not vital, the museum is literally just a backdrop and just a venue, then an Article 10 is not required for that. And then you might get any kind of activities behind the scenes. So if you are charging your visitors to view a storage area where the Annex A specimens are one of the focuses of that tour, then a certificate would be required. However, if visitors are just being charged to view the general storage area and the Annex A specimens aren't the focus, then no certificate is required for that. Finally, the use of images. Obviously, if your filming or photography is focused specifically on Annex A specimens or their display, then it is required. But if it's not specifically targeting Annex A specimens, then it is not required. If you are in any doubt, I would always recommend that you seek the advice of APHA as the management authority. Another aspect of CITES that might be of particular interest to some scientific institutions is the labelling scheme, whereby scientific institutions become registered, and the labelling scheme really is to encourage scientific institutions to facilitate the exchange of specimens between institutions or between researchers. So with the intention that it reduces any take from the wild in order to bring them in for research, that full proper use is made of any specimens that are already available. And CITES has conference resolution 1115. This is available, can be viewed on the CITES website. And it encourages all parties to register their scientific institutions, to kind of encourage them to inventory your holdings and make that information widely available, and to parties and the research community to kind of facilitate exchange for scientific research. And so when you get registered with the management authority, the MA will issue kind of give you some pre-issued labels so that you can package up your samples and just stick the label on it and pop it in the post, or whatever transport means you need to use. I think you are required to return labels, kind of you get like a little ticket so that you can provide full details of all the labels that have been used and what they were sent for. And there's certain criteria that has to be met in order for this labelling scheme to be used, but you can find full details of all the criteria and the standards that need to be met in the conference resolution. Okay, very quickly, I will just move on to the Wildlife and Countryside Act. So the Wildlife and Countryside Act came into force in 1981, and it was enacted primarily to implement a couple of European agreements, the Birds Directive and the Berne Convention. So it's the domestic legislation in Great Britain, and it replaces previous wildlife legislation, such as the Protection of Birds Act, which was enacted in 1954, and the Conservation of Wild Creatures and Wild Plants Act of 1975. So the 1981 Wildlife and Countryside Act covers all the provisions made in those previous acts and provides kind of additional provision for the species and countryside protection, such as prohibiting certain methods of killing or taking. It amends the law relating to the protection of certain mammals. It amends the law in relation to nature conservation and the countryside and to public rights of way. And it was quite a significant piece of nature conservation legislation when it came in its time. It's quite a dynamic bit of legislation as well, because there have been various amendments to the Act, but there's also a statutory requirement to review Schedules 5 and 8 every 5 years. Schedules 5 and 8 are protected wild animals and protected wild plants. So the species listed on those schedules are reviewed every 5 years, and this review is actually coordinated by JNCC. Northern Ireland does have equivalent provisions, and I think you can find the most up-to-date version of the Wildlife and Countryside Act on the .gov website. I thought it might be helpful to flag up the existence of some information that I think you might find useful. Because I have colleagues at JNCC that work on the Wildlife and Countryside Act and the quinquennial review of the schedules, they have created a compilation of UK species that are subject to international agreements, UK legislation, UK country lists, and those with a particular conservation status. For example, they're listed on the IUCN Red List. Now, this spreadsheet is on the JNCC website. The address there is on the slide, so it is publicly available. It is, if you went to the JNCC website, you could either Google conservation designations for UK taxa, or you can go into the JNCC website and kind of find your way there. But I've highlighted the link on the side of the slide there. And if you click on that link, it takes you through to a humongous web spreadsheet. The spreadsheet has 5 tabs. I selected the summary for each taxon tab, and then I filtered the spreadsheet by selecting the CITES Convention in column K and the Wildlife and Countryside Act in column Y, which then gave me a list of 61 UK taxa that are listed both on CITES and on any one of the schedules of the Wildlife and Countryside Act. And the spreadsheet will also confirm what schedule the taxa is listed in. So as far as the Wildlife and Countryside Act kind of linking over and crossing over into our CITES considerations, there aren't too many cases where it does this. That is particularly pertinent to yourselves. However, it's just worth noting that any permits or certificates that we issue for a UK native species would require a legal acquisition finding and may also require a non-detriment finding, depending on what annex it is listed on. And so obviously for a wild sourced UK native species, this would include a check to make sure that the specimen was obtained in accordance with the relevant provisions of the Wildlife and Countryside Act. And so if ever you are intending to make an application for such a specimen, then providing full details of the origin and the acquisition and any supporting documentation that you have would be extremely helpful in helping us to assess that application. And there's my contact details. Thank you very much for listening, and I will stop sharing my screen and I will put my camera back on and take some questions.
Thank you so much, Nichola. That was fascinating. We've had questions coming in. Sophie Stevens said, "Hi, are JNCC able to provide advice in situations, in situations where there seems to be a confusion over the species with AFA? I had a situation last year when I was repeatedly told by various AFA advisors that needed an Article 10 to display a fallow deer specimen despite it being a subspecies that is listed on CITES."
Okay, yeah, I can answer that. So CITES is a global convention. It's a global treaty. So obviously you have multiple languages there. In addition, you know, there are many different scientific and common names for species depending on which author you choose. So the CITES parties agree a set of standard nomenclatorial references that they all agree to use. And this means that all the parties throughout the world will be referring to the same scientific name that is applied to species. Unfortunately, CITES lags behind the rest of the scientific community because these nomenclatorial references are only agreed every 3 years at the Conference of the Parties. So if there's new information, new evidence that comes to light, new papers coming out that show that it should be called something else, so it should be in another genus or something, then we are often a few years behind the rest of the world. However, permits must be issued with CITES standard nomenclatorial references. In addition, you mentioned subspecies, and normally if a species is listed on CITES, all the subspecies are automatically included under that species name. So we don't often go down to subspecies level. We only go to subspecies level if a subspecies is listed on a different appendix to the nominate form. Maybe a subspecies is more highly threatened by trade than the nominate, in which case it will be listed, split listed on a different appendix. But normally all the subspecies are included at the species level. So just applying the species name is adequate for CITES permits.
Okay, thank you. Emily Pearson says, "How do you determine whether a Cat A specimen is the main focus or on an event tour?" So I guess that's relating to when it was talking about,
So how do you judge whether an Annex A specimen is a primary focus on a tour?
If it was rhinos today, then yes, but if it's kind of as part of a whole,
it's a bit of a judgment call, to be honest, and it's a judgment call that the management authority need to make. If it's, if you have rather a lot of Annex A specimens, and they're all visited as part of your tour, then you could say, well, the majority of species, shown to the public as part of that tour were Annex A. But if you're showing them 20 specimens and only 2 of them are Annex A, then it's like, okay, well, it wasn't really it wasn't really the primary focus, was it? It's a bit of a judgment call. So that's why I said, if you're in any doubt, it's probably best to discuss it with the management authority and get their advice, because it is difficult to interpret. There are so many different scenarios, aren't there, and different kind of nuances and tweaks depending on what you're doing. It's all a bit case by case. So
Nathan has said he has a question about the country of origin. If the specimen has historically pre-CITES hunted in the wild, and then brought to the UK to be taxidermied, it is now considered worked and considerably altered from its original state. Could the country of origin now be the UK instead of whichever country it was hunted in, historically pre-CITES, owing to the significant alteration? Another example could be an elephant tusk carved in the UK.
Okay, so specimens that are pre-convention normally have source code unknown, because ultimately you don't know which country it came from. In terms of newer specimens, if you import something from South Africa, the country of origin is South Africa. If you can trace it back to the country where it came from, then that is the country of origin, and that doesn't change if you do something to it, at a later date. The country of origin is the country of origin, but generally for pre-convention items, you don't know it, so it's unknown.
Mm-hmm. Yvette Harvey is saying, great talk, thank you. I have a question about putting images of Annex A, sorry, it's jumping around here, of Annex A, Appendix 1 herbarium plant specimens online. Apologies, I am showing animal blindness. Essentially to redact or not to redact wild location locality data from visible specimen label to avoid predation or harvesting. So, and how about similar for Annex B or C, Appendix 2 or 3? Do Q or a herbaria, or, are people asking to redact locality information?
I think it might be a sensible idea if the species is only available in a few localities, and it's endangered. I think it's probably sensible not to advertise the localities. But was that just a question, or was there a concern about commercial use and putting an image online? Because if you're not benefiting commercially from putting that image online, then there's no need for an Article 10. It's only if you are somehow benefiting commercially from the use. So I worry so much about that.
Sophie's saying that after they submitted the application, we were then told that our assumption was correct and that they didn't require an Article 10. So Jack's saying, years ago, NatSCA worked closely with the AHVLA to produce the CITES Guidance Note 20 about how and when CITES apply to museums. It was very helpful, but is no longer available, I think, on the DEFRA or AFA sites. Is there any way it could be resurrected? It's currently findable on the National Archive site, and then he's put a link in the chat.
Yeah, so I remember there used to be a lot of guidance notes on AHVLA's website for customers, and I think the reason that a lot of them were taken down was partly because there was a resource implication in keeping them all updated. Obviously, it's important to make sure that the information you give out to customers is correct, and also so there was a resource implication, and I think also it can be difficult to put things on the .gov website, believe it or not. I think they don't like things to be too technical. It's funny, we've been talking about this just in the last couple of days, and resurrecting, I think they're now coming back round to the opinion that there does need to be more guidance out there, and we are now discussing how best to do that, given that it's difficult to put things on the .gov website because neither JNCC, Q, APHA or DEFRA are able to go on ourselves and amend it. We don't have control of that website, so we have to go through another body to do that. And also they like everything on the .gov website to be very simple, so they see it as being, it's got to be understandable, and so they like things written like it's for an 8-year-old or something, but actually then it's you dumb down the information so much it becomes inaccurate. and the unintended implication of having information that's been dumbed down that much is and inaccurate is that when it comes to wildlife crime prosecutions, if the guidance is not clear, then prosecutions will fall through because the defence will argue that the guidance wasn't clear. So we are now, I will feed that back into the discussions because, I don't disagree. I will feed it in. I've got a meeting next week in York and I will feed that in. But that's the reason why they were removed in the first place. But if you do have questions, you can either, contact ourselves or Q or APHA. If there are any guidance questions that you do need, then do contact and ask.
Robin's saying, if we get donations of Appendix A species from relatives of a deceased person that no longer have documentation associated, are we able to accept the donation without import-export CITES permits? Quite a lot of people that have said that they've had similar issues.
Okay, that's a very good question. I'm glad it was brought up. So, do I assume that these are donations from within the UK?
Well, so Amy at the National Museums of Ireland has also turned down similar issues.
Okay, well, if you're accepting donations of Annex A specimens, appreciate that the owner may not have documentation, but I would encourage you to obtain full details of the specimen that you are acquiring, because further down the line, if you do need an Article 10 or you need to get an import or an export permit for it further down the line, you need to be able to firstly demonstrate legal acquisition, and secondly, you will be asked for some details of the history of the specimen. So it would make really good sense to acquire as much information as you can when you are accepting the donation. So the name and address of the previous owner, the date they acquired it, even the year, the date that they acquired it, any known information that they can tell you about it, even if it was it's been in my loft for 50 years, or I inherited it from my granddad who shot it in Namibia in the 1920s, or any information like that at all will help us to date it. They might be able to provide you with like family photos from the 1970s with this item in it. Look a bit wider and think of any evidence at all that they might be able to provide you with. And I think so long as you get that and perhaps a gifting letter or some signed affidavit, so that you can also demonstrate that you acquired it legally, then I think you've done the best you can,
Yeah, and I've done similar things in the past where I've had, got people to write, letters with all of the description of, it was my great granddad's, it's just been in the family. Half of us don't really know what it is, but all of a sudden it's, in the subsequent years it's become rare, even though perhaps it was something that sailors used to trade regularly.
Yeah, absolutely. Yeah, absolutely.
Simon has had his hand up for a very long time, and Kevin, who is our next speaker, also has his hand up. I am very well aware, Kevin, that we are eating into your time. I'm happy for us to run over if you are, but I know that you do have to whiz off soon. So
my contact details are on the slide, so if anybody does want to email me afterwards, I'm happy to answer any questions.
Yes, thank you so much, Nichola. There was tons of questions.
No worries.